Good evening to those of you in Hong Kong. Good morning, good afternoon to those of you in other parts of the world, and welcome to this Zoom talk hosted by the Transnational Legal History Group, a subgroup of CUHK Law's Center for Comparative and Transnational Law. We are immensely fortunate to be joined today by Professor Jack Jing Gary Lee. The title of Professor Lee's talk today is Protecting Women and Morals, Contagious Diseases Laws and the Rule of Law Ideal in the British Empire, 1886 to 1899. So as that title suggests, I'm sure we'll have many fascinating contemporary resonances to think through as well. After Professor Lee's talk, we hope to have, or we will have a period for questions and answers. If you have any questions during the talk, please send them in to me using the chat feature on Zoom, and I will present them to Professor Lee, or if you prefer, I can unmute you so that you can join us directly to the extent possible in this increasingly virtual world, to ask the questions yourselves. Our hope is very much to facilitate an engaged discussion, so please do send in any questions you might have. For your information, let me note the event will be recorded and posted on the center's website. So if you want to rewatch it or share the link with colleagues, it will in short order be available there as well. So without further ado, let me hand over the floor to Professor Lee. You've just gone muted.
Sorry, technology issues. Thank you, Professor Roberts, and also thank you very much to the CUHK staff. I will be sharing my screen very briefly, so give me a few seconds to get it adjusted. There we go. I hope you have you see my screen now. Okay, that's perfect. So let me begin. So how did liberal ideals like the rule of law shape Britain's imperial project? Does liberalism limit empire, or does it channel the projection of power toward populations that do not fit with liberalism's so-called anthropological minimum, to quote Uday Mehta? In many a critical study of colonialism and empire, liberalism and its ideals matter less in the formation of the colonial state than the canny machinations of elites, both metropolitan and local, and their misunderstandings of the colonies. Hence, officials' treatment of the colonized and their fidelity to liberal principles like the rule of law will warped by their investments in and misrecognition of the colonies and their inhabitants. So from this perspective, the temptations and politics of empire corrupt liberalism and the rule of law. In this view, liberal ideals do not shape empire. Nevertheless, the question of liberalism's role in empire lingers because colonial officials could and did take their commitments to the rule of law seriously and sought to translate their ideals of legality and individual freedoms into colonial law itself. No less a figure than Sir James Stephen, who was the first legal counsel and then permanent Undersecretary of State for the colonies during the transformative period of emancipation, was described by scholar Keely McBride as, quote, someone with an intense conscience and spiritual belief who was a critic of British colonialism, end quote. Similar things could be said of George William Johnson, a clerk in the Eastern Department of the Colonial Office towards the end of the 19th century. Johnson, notably, was a key ally of the English social reformer Josephine Butler in her campaign against the regulation of prostitution across the British Empire. This was a struggle that sought to remove women from the intrusive surveillance of officials. So in practice, while colonialism rested on foundational acts of conquest, colonial administration also spoke the language of beneficence, legality, and protection as officials wrestled with new subject populations. So focusing on the regulation of prostitution, this talk proposes that the recurring claims of the liberal ideal of the rule of law among colonial elites, far from being an ideological cover or an endowment of colonial rule, gave form to the racialist racialized structure of gendered sovereignty that was established in the British Empire. Sovereignty in this case is not only a relation of domination mediated by physical violence. Sovereignty as an articulation of power is also bound up in law and its understandings of the rights and obligations between sovereign and subject. In Britain's liberal empire, the protection of colonial subjects' liberties under law formed as much a part of the language of sovereignty as calls for law suspension in times of emergency. So to understand the relation between law's promise of protection and the imperative to maintain imperial control through force, this study examines officials' efforts to abolish the regulation of prostitution in Britain's directly ruled colonies. This was an affair marked by repeated clashes over the freedom of native women who were subject to expensive modes of medical and administrative control. Because of their importance in the empire-wide campaign to protect women through or from regulation, I focused on the colonies of the Straits Settlements, that is Singapore, Penang, and Malacca, and Hong Kong, where regulation continued despite such efforts to abolish it. Now, the puzzle posed by the debates over the imperial regulation of prostitution lies in the peculiar resonance of the rule of law in the debates over the protection of native women. By the 1880s, when the Contagious Diseases Ordinances, or the CD Ordinances as I'll refer to them thereafter, that targeted women as carriers of venereal disease were subject to a growing well of criticism, debates between elites in the metropole and colonies centered on the question of whether native prostitutes were so-called free agents who should be protected from the regime of compulsory medical examination imposed by these laws. So whereas abolitionists, those who were against regulation, and their allies emphasized the potential for officials' abuse of their powers over vulnerable women, those who desired the regulation of prostitution insisted on native prostitutes' lack of freedom due to the bonds that tied them to the brothel keepers. Framed by the rule of law task of individual rights and freedoms, the moralistic tone of this discourse was maintained even when the CD ordinances were repealed and replaced by the Protection of Women and Girls Ordinances, which criminalized trafficking and related forms of sexual conduct in the Straits Settlements and Hong Kong. Confronted by native prostitution and the spread of venereal diseases at the edges of its empire, Britain's liberal empire could be said to be exercised by what Geoffrey Kahn calls, quote, the tension between a foundational submission to constraining legalities and the yearning for a sovereign flexibility by which such factors may be thrown aside, end quote. So, translated into the struggles over the regulation of prostitution, this foundational tension of liberal imperialism took the form of vigorous disagreements between colonial officials who contended over the protection of working-class native populations. If it's not clear when I say native, I really mean it in quotation marks, mainly because the term was used fairly loosely during the course of the British Empire, referring to people who were in fact indigenous and people who were, say, imported forms of labor but were non-white. So let me go back. Critically, my talk today demonstrates how these tensions, far from being an auxiliary symptom of imperial expansion, were in fact constitutive of what Pater Chatterjee calls the rule of colonial difference. That is to say, the pernicious principle of racial hierarchy in the colonies and across the empire. Delving into the formation of the rule of colonial difference through the story of these ordinances, I argue that 1, the production of gendered sovereignty in empire took the form of laws that outlined the colonial state's protective role vis-a-vis native women. And 2, it was driven by the differing ways colonial officials and elites formulated their commitments to the rule of law ideal. The rule of law, given its ontological commitments to individual rights, provided then an evocative framework of beneficence, legality, and protection against which officials could define and compare the kinds of difference that mattered in colonial rule. Within this frame, comparison generated a differentiated sovereignty, as colonial officials formulated the legal protections granted to native women based on evaluations of the latter's racial character. So to briefly return to the question I began with, the rule of law was in fact central to imperial politics and colonial lawmaking. However, rather than view it as a rhetorical front for imperial interests, or a common law transplant that limits the power of the colonial state, my argument actually takes this ideal as what Isaac Reed calls, quote, a landscape of meaning, end quote. That is to say, a historically constituted language of discursive formation that allowed colonial officials and elites to project their respective images of social difference and invest these representations with emotional force, with moral force. Understood in terms of the rule of law, Native women's freedoms could be imagined and also identified as a deserved object of colonial lawmaking. So preceding the proliferation of rule of law indices and indicators in our globalized present, law legality already provided the language of judgment and social classification in the modern British Empire. In relation to the morally charged issue of prostitution, it was important for colonial officials to establish whether Native women possessed the freedom to seek treatment for venereal diseases. If not, official intervention seemed necessary to protect them. The products of these debates between officials and elites were laws that then imposed standards, rules, and sanctions on the sexual and social lives of Native women in the crown colonies of the Straits Settlements and Hong Kong. Established in the form of the CD and then later on the Protection of Women and Girls Ordinances, a racialized form of gendered sovereignty was enacted and justified in terms of the Crown's protection of Native women's freedoms. So in what follows, this talk, I will turn to the genealogy of the rule of law to identify its roots in the tempering of sovereign power. Then I outline the concept of gendered sovereignty and discuss the methodology of my historical ethnography of the rule of law. And finally, I'll examine the interconnected cases of Hong Kong and the Straits Settlements and show how implications of the rule of law ideal in the repeal of the CD ordinances by the Protection of Women and Girls Ordinances maintain the regulation of Native women in a new guise. So the rule of law gained particular prominence in the second half of the 19th century. In the classic formulation of the Victorian jurist A.V. Dicey, Albert Van Dicey, the concept characterized three interrelated aspects of Britain's political and legal institutions. One, quote, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power. Two, quote, equality before law or the equal subjection of all classes to the ordinary law of the land administered by the ordinary law courts, end quote. And three, open quote, the fact that with us, and this is my words, Englishmen, the law of the Constitution, and back to Dicey here, the law of the Constitution is not the source but the consequence of the rights of individuals as defined and enforced by the courts, end quote. So my point of departure lies in the rootedness of Dicey's definition in the historical self-understanding of the English. In the third set, Dicey proposes the rule of law meant the preponderance of judges in determining the validity of state actions based on their pre-existing conceptions of the rights of individuals. But in Dicey's ethnocentric formulation, Britain's constitutional laws originated in the distinct rights of Englishmen. So when set against its jurisprudential genealogy, Dicey's definition reveals the political basis of English personhood and identity. Specifically, in explaining how the courts were the institutional basis of rights already inherent to those under the jurisdiction of the Crown, Dicey referred his readers to a series of cases, the most notable of which was Calvin's case in 1608. While Calvin's case, which granted the Scottish subjects of the Crown legal protections in England, indeed demonstrated the pivotal role of judges in determining the rights of Englishmen, Dicey's citation of Sir Edward Coke's foundational opinion elided the fact that the latter also established how individual rights were rooted in a framework of sovereignty and obligation. Simply put, allegiance, not one's identity as an Englishman, was the basis of an individual subject's protection and rights. Now, revisiting Sir Edward Coke's dicta, we find that law's protections are, let me get adjusted, are based on what Coke calls the allegiance, faith, and obedience of the subject to the sovereign, end quote. Hence, I contend that instead of being seen as a constitutional arrangement derived from rights peculiar to Englishmen, the rule of law is better grasped as the historical product of the tempering of sovereign power by judicially enforced obligations to the governed. As Martin Krieger, in his reading of the various rule of law traditions, states of the problem that they aim to solve, the focus, and open quote, the focus is on power and how it is exercised. That is the place to start, end quote. So looked onto the historical project of tempering sovereign power, our inquiry into the significance of the rule of law takes a form that is familiar to social theory. How is power organized? What underlies the stability of power and its institutions? Why do social actors recognize and submit to the authority of others? Now, in this light, the historical emergence of the rule of law presented a distinct solution to the potential instability of the social relations that undergird sovereign power. In the early modern British Empire, the Crown's promise of the rule of law and representative government came to be seen as important undertakings for drawing private investment and settlement in the colonies. As Lord Mansfield opined on the decision to call an elected legislative assembly in Granada, in Campbell v. Hall, decided in 1774, quote, "With what view is this proclamation made? It is to invite settlers and subjects. And why to invite? That they might think their properties and so on and so forth more secure," end quote. However, British officials and elites' claims of the rule of law across the empire can neither be dismissed as ideological cover for the Crown's material interests or as an institution transplanted by settlers across a so-called empire of liberty. The rule of law did provide actionable rights, and the British did not convey the rule of law overseas as the undisputed right of settlers. Rather, the meanings of the rule of law arguably emerged with the projection and negotiation of sovereign power across new lands and peoples. Understood as part of the language of imperial sovereignty and protection, appeals to the rule of law made sense in policy discourse as claims to negotiate the reach of sovereign power and to establish the legal protections and recourse afforded to colonial subjects. My analysis of the rule of law builds on Nick Cheeseman's proposal for the study of the rule of law in terms of its asymmetric opposition to other ideals. In his work on the transformation of the rule of law in colonial and post-colonial Myanmar, Cheeseman takes up Carl Schmitt's insight into the distinction between, quote, the principle of the rule of law as normatively binding and delimiting of political action, and the principle of sovereign discretion, or the sovereign will. So while the divergent rationalities of the rule of law and what Cheeseman calls law and order is salient in critiquing how colonial and post-colonial states turn away from and abuse the rule of law ideal to consolidate political control in the form of law and order, my analysis of the debates over the regulation of prostitution reveals how the tension between the rule of law and the order-making claims of sovereign power can paradoxically sustain the rule of law ideal while extending the state's reach over new subject populations, and domains of social life. So we might ask then, what then is produced by the implications of the rule of law in policy discourse? The answer, as I outlined here, lies in the origins of the rule of law in the relationship between sovereign and subject. Contra, or that is unlike Dicey's view of the rule of law as being based on the rights of Englishmen, rule of law claims in colonial policy lawmaking or imperial policy making construct the reach of sovereign power and its legal obligations towards the governed. In the context of Britain's racially diverse empire, officials' concerns with legality and statecraft constituted the Crown's differential relations to subjects, who were then distributed in legalized hierarchies of race, gender, and class. Under the premise of the protection of differently classified subjects, officials formulated laws that extended the control over new domains of population. Thus harnessed, the rule of law as practice created the framework for the articulation of the rule of colonial difference. Britain's empire was dramatically remade in the 19th century as the Crown's officials turned away from the routine grant of elected assemblies, particularly in the Atlantic Empire, to preserve the control over colonial lawmaking. Constitutionally, officials devised new arrangements, direct rule, indirect rule, and self-government, all of which I'm happy to talk about, to rule a diverse, changing empire. In the ferment of these developments, officials also constructed modes of imperial control, including what I call gendered sovereignty, to discipline racially different subject populations. In the Straits Settlements in Hong Kong, officials and elites faced with sexual commerce and the demographic imbalances created by colonial capitalism sought to manage the various issues, for example, venereal diseases and trafficking, associated with the influx of Chinese and other women who became entangled in the sex trade. gendered sovereignty, which articulated male officials and elites' views of their authority and obligations as protectors of native women in law, thus subjected colonized populations to gender and racialized forms of control. So let's take the treatment of the migrant Chinese populations, for example. While working class men encountered the colonial state as coolies or members of criminalized secret societies or huis, women were typically seen as prostitutes who could be subject to registration, compulsory medical examination, or detention for treatment. Gendered sovereignty, framing in the legal form of the imperial regulation of prostitution, expanded the scope of the rule of colonial difference by targeting native women. With the imposition of the CD and then the Protection of Women and Girls Ordinances, native women were defined as persons whose sexual activities and movements were to be monitored and controlled due to their association with prostitution. Even though the language of these ordinances explicitly define women and their freedoms as objects of protection, referring implicitly to the rule of law, the laws extended the colonial state's regulatory powers over sex and social life. So prior accounts of the regulation of prostitution that you can see here on my slide in the British Empire have highlighted how sexual practices were integral to the maintenance of empire and its rule of colonial difference. Philippa Levine's Magisterial History of Prostitution and CD Laws in Hong Kong, India, Queensland, and the Straits Settlements demonstrates how the racial consciousness and politics of empire was shaped by colonial medicine, women, and the global influence of laws, ideas, and prejudices. In the same vein, Philip Howell's study of regulation across the interconnected geographies of Liverpool, Cambridge, Gibraltar, and Hong Kong argues that the mobility of ideas, knowledge, and officials in the practice of regulation show that, quote, the regulation of prostitution in Britain and the rest of empire was part of the same project, home or away, end quote. And finally, James Warren's in-depth and frankly touching social history of prostitution in the Straits Settlements draws on coroner's reports to examine the lives and afflictions of Chinese and Japanese women who were caught up in the sex trade in Singapore. Drawing upon their work, this study focuses on the global significance of the rule of law, its place in imperial control, and the complex processes of colonial lawmaking. As my analysis shows, what is distinctive about the making of gendered sovereignty in the imperial control of prostitution is the rule of law ideals used as an evaluative frame in determining the legal status and protections of native women. So in its method, my study answers the call for rule of law ethnography. And to do so, it develops a historical ethnography of the rule of law by following the to and fro processes of colonial lawmaking that bound the British Empire together. So as theorized by Cheeseman, 4 qualities characterize rule of law ethnography. It is located, relational in a symbolic and social sense, comparative, and oriented to the extrinsic value of the rule of law, end quote. So the last is key. The method is committed to what Cheeseman calls following the rule of law idea or some other idea with which it's related through observable arrangements of meaning that change over time. When applied to the historical ethnographic analysis of colonial lawmaking, this entails a careful tracing and reconstruction of how the rule of law idea has been invoked and perhaps sometimes institutionalized, starting from when the idea was first mooted to its translation into legal forms. Embedded in the documentary flow of colonial correspondence, the historical ethnographer can then sketch the associations, oppositions, and the uses of the rule of law ideal and its rhetoric. One can then show, as I do, that the rule of law was formulated in opposing ways by officials and elites in relation to the social and medical problems tied to prostitution. Also, my historical ethnography of the rule of law raises questions in turn about the comparative sensibilities of these lawmakers. The approach actually is facilitated. This approach is facilitated by the bureaucratic structure and practices of imperial control in the modern British Empire. The colonial office was in fact central to colonial lawmaking. Besides exercising powers of disallowance over colonial laws, they supervised the membership and proceedings of the colonial legislative councils. In directing and controlling colonial lawmaking as kind of a control center of sorts, officials were meticulous in drafting correspondence, which conveyed the representations, opinions, and feelings on colonial societies. As one Straits Settlements governor wrote against the policy to end the medical examination of Native women, quote, "To abandon compulsory examination is to continue one of the gravest abuses resulting from brothel slavery," end quote. As the term brothel slavery reveals, the prosaic process of lawmaking could generate evocative comparisons as lawmakers sought to harness the moral weight of policy precedent, that is, here in this case, emancipation, and by implication, the rule of law ideal. Utilizing this manner to impose similar classifications and policies upon populations, colonial officials and elites' use of comparison was hardly an objective or ideological neutral act. Comparison is better understood, as I argue here, along with using Anne Stoller's words, quote, "an active political verb," end quote, "an active political verb," end quote, that requires the actor to draw upon their presupposition and ideals in validating social phenomena, both past and present, and in determining their future courses of action. So premised on their sense of self and their ideals, officials and elites' comparisons of populations and practices sought to realize the project of a liberal empire that promised progress to the subaltern. Invested in the rule of law ideal as a source of self-understanding and an object of empire, colonial officials and elites viewed diverse subject populations as vulnerable persons whose freedoms had to be protected under law. So therefore, in calling the organized sex trade brothel slavery, they could not only declare the salience of a social problem, but also impose the regulatory force of the colonial state on categorically differentiated different persons and places. What was also produced in these practices was a calibrated projection of sovereign power whenever officials and elites identified just how individual liberties were violated by native practices and corruption. To put it very simply, comparison fostered a differentiated mode of sovereignty. So at its first glance, I'm going to turn now to talking about the CD ordinances and how they were first instituted. At first glance, the diffusion of CD ordinances across the empire seems symptomatic of centralized imperial control. Colonial laws were passed mostly in the wake of Parliament's enactments of the Contagious Diseases Acts, the CD Acts, and the acts. The parliamentary acts were enacted to tackle the increase of venereal diseases in the military and targeted prostitutes in designated areas where military garrisons were based. Similar laws were enacted by the colonies. In official returns presented to Parliament in 1886 and 1887, 17 out of the then 45 colonies, so roughly more than one-third, submitted measures that they used to apply the principle of the CD Acts. So for example, in Jamaica, the provisions for the compulsory medical examination of women identified by police as what they call common prostitutes in its 1867 CD ordinance mirrored Parliament's 1866 CD Act. However, this story misses one particular curious fact. Some colonial ordinances preceded the acts of Parliament, the most significant of which would be Hong Kong's, where the earliest law aimed at the spread of venereal diseases actually was enacted in 1857, before the first CD Act of Parliament. Hong Kong's ordinance for tracking the spread of venereal diseases controlled prostitution through the inspection of brothels and their inmates. Devised by Governor John Bowring, who was an ally of Jeremy Bentham, as a solution to the problem of prostitution tied to the influx of Chinese labor, it required, one, the licensing of brothels, and two, the periodic medical inspection of prostitutes, amongst others. The colony's ordinance began with the designation of a prostitute as, quote, any woman who shall live or reside in a registered or declared brothel, whereas the definition of a brothel, whether declared or registered by the colonies, included houses where women lived, resided, were kept, or merely frequented for the purposes of prostitution. Hong Kong's approach evinces officials' understandings of the organized nature of prostitution in a predominantly Chinese population, and when enacted, the then Secretary of State of the colonies, Henry Lavoisier, thought it would aid women sold into brothel slavery. Now, Hong Kong's approach would be later adopted in the Straits Settlements, and on the grounds of their similar social conditions. presented as a necessary solution to the exploitative practices of Chinese brothels and criminalized secret societies, the colonial regulation of prostitution in the Straits Settlements was, like in Hong Kong, seen as a panacea or as a solution for brothel slavery. Here, the figure of the unfree Chinese woman who could not seek the protection of the law stood in the foreground of colonial lawmakers' justification of the ordinance. This was an Orientalist mode of regulation, premised on official self-professed knowledge of oppressive native practices and the desire to establish the rule of law. Witness here the law's invocation of the magistrate's duty to protect the vulnerable. Now, crafted upon this basis, the law reinforced an essentialist difference between the colonizer and the colonized. In contrast to colonies, for example, Jamaica, that I talked about briefly earlier, that mimicked the language of the parliamentary acts but implemented the law differently in practice, the ordinances of Hong Kong and the Straits Settlements, in fact, encoded and racialized and gendered social order in statutory law. Now, with the passing of the city ordinances across various colonies, the regulation of prostitution as an imperial project took on pattern forms across the empire, focusing on either common prostitutes or brothels and their inmates as key subjects of medical surveillance. Critically, the spread of the city ordinances across the British Empire provoked the opposition of a growing abolitionist movement led by Josephine Butler. And as Josephine Butler argued, the problem of the acts lay in the centralization of authority and the, quote, what she called the establishment of a system of police espionage that these laws introduced, end quote, into English life. Furthermore, the spread of the city laws in empire did not only impose a double standard when they targeted women rather than the men who frequented prostitutes. These measures also placed women under a regulatory regime unchecked by procedural safeguards. At the very heart of the objections of the abolitionists lay the rules for the compulsory examination of women, which they found deeply repugnant. So here we go. So as the movement to abolish regulation gained political support in Britain itself, and then later across the empire, the characterization of these laws also gained ground across the imperial control apparatus as officials at Whitehall began to respond and were compelled to respond to the abolitionist criticisms. After the repeal of the City Acts by Parliament in 1886, the Secretary of State to the colonies wrote to the Crown colonies with city laws, the directly ruled colonies with city ordinances, asking to be furnished, quote, furnished with any special reasons, end quote, for their maintenance. The colonies' responses to this implicit call for repeal were in fact quite mixed. Notably, the colonial officers' insistence on the abolition of the medical surveillance, i.e. the compulsory examination of women, allowed for exceptions. While repeal failed ultimately in Malta after constitutional changes limited the colonial officers' control over legislation in Malta itself, the Secretary of State tentatively accepted claims that the city ordinances protected native Fijians from venereal diseases brought in by immigrant workers. Fiji city law was later repealed, leaving Hong Kong and the Straits Settlements as the only colonies where regulation continued in the alternate form of the protection of women and girls ordinances. And this is a legal transformation to which I now turn. In the campaign to repeal the city ordinances, metropolitan actors were called to evaluate and act on the arguments of local elites and officials. The sovereign power to determine the rights of colonial subjects was, in practice, distributed across officials who possessed powers to evaluate and decide the formulation of colonial legislation. Now, taking place in the shadow of the authoritarian structure of government in directly ruled crown colonies and the crown's powers to disallow colonial legislation, these moments of official judgment shaped the process of repeal. Now, as the colonial officers' request for reasons to maintain the regulation of prostitution initially faced strong opposition in Hong Kong, before communication on the matter lapsed, the repeal of the city ordinances by the Protection of Women and Girls Ordinances first took form actually in the Straits Settlements, where local officials were responsive. There, the debate over regulation was powerfully shaped by the then protector of Chinese, William Pickering, whose efforts were instrumental in framing the problem of prostitution and diseases in the protection of women. You see him on the left side of the slide here. When Governor Frederick Well of the Straits Settlements answered the Colonial Office's request for special reasons to keep the colonies CD ordinance, he presented Pickering's report, stressing the protector's view that the law was, quote, absolutely necessary for the protection of women and children, and that to abolish them would be to regulate a very large number of females to a state of slavery, end quote. Rendered in the stark terms of life and death, Pickering's impassioned argument for the enhancement of the law was an argument for basically the moral force of beneficent protective legality. Dissenting views were in fact voiced in the colony's executive council, which is a cabinet-like body that advised the governor. And this included the views of the Commissioner of Land Titles, William Maxwell. The opinion of the legal-minded Maxwell, who was also the son of the colony's first Chief Justice, was significant as it echoed the abolitionist concerns for the abuse of women. To Maxwell, Pickering missed the real question of the protection of women and children. Regulation needed to be justified by its efficacy and avoid the abuse of powers granted to officials. In relation, he argued that there was no evidence that the CD ordinance had reduced the incidence of venereal disease and that the law enabled what he called the gross immorality of officials and others in their targeting of women of other races. Nevertheless, Maxwell's views on Native women did not differ greatly from Pickering's. Both men, in fact, viewed Native women and children as vulnerable subjects who needed legal protection. Their disagreement, in fact, lay in how this protection should be enacted. At the very heart, the moral concerns over the consequences of the repeal or continuation of the CD law, expressed by Pickering and Maxwell respectively, assumed the protective role of the colonial state in relation to Native women and children. Echoing the rule of law ideal, the liberties of these subjects were to be guaranteed. It was either necessary to secure the freedom and welfare of the inmates of brothels from their keepers through medical examination, or it was critical that Native women no longer suffered the abuses wrought by corrupt informers or officials armed with powers to subject Native women to medical examination against their will. As suggested by Maxwell's vivid analogy of the deployment of gunboats to, quote, put down the slave trade on the coast of Africa, liberty and the rule of law in the British Empire were founded upon the projection of sovereign power. In other words, the freedoms and rights of colonial subjects could only be constituted by the colonial state's extension of its authority over native society. Upon the receipt of the Straits Settlements response, the Colonial Office deliberated over the colony's reasons for keeping its ordinance. George Johnson, who I mentioned earlier, clerk in the Eastern Department, was then, not surprisingly, the first to respond. Unlike Pickering, he did not think that compulsory examination of women was necessary, insisting, and here expressing his abolitionist views, that, quote, we must, I think, use other means, gradually to convince the women that they are free to come and go as they like, including the hospitals, end quote. As an ardent abolitionist, Johnson did not stop at rebutting arguments for forced medical examinations. The target for him was the entire system of the regulation of prostitution, which included the registration of brothels. He, like Maxwell, expressed concern over the powers of local subaltern officials, highlighting, quote, the abuses thereof occurring in the Straits Settlements as everywhere else, where registration, that is, has been tried, end quote. Now, in response, John Ramsden, his superior, and also the Assistant Undersecretary of State, opposed the repeal of regulation altogether. While he agreed that medical reasons were not sufficient to continue the examination of women, Ramsden insisted on the need for brothel registration. Seeing native immorality as a vice to be curbed, Ramsden's position was opposed to and also superseded Johnson's support for the complete deregulation of prostitution. This meant that the Secretary of State subsequent instructions to the governor called then for the end of the compulsory medical examination of women, but continued the registration of brothels through an ordinance to protect women and girls. And these exchanges between the colony and the colonial office caused the repeal regulation across the empire were eventually obscured by what officials felt to be the greater imperative to protect women, native women, maintaining, in fact, the structure of gendered sovereignty. So the question here is this: could native prostitutes be free agents? The question also weighed heavily on the debates over the CD ordinances in Hong Kong. Through delay and other forms of resistance, Hong Kong's colonial government resisted the colonial office's policy of repeal. In their responses to the Secretary of State initial request for special reasons to continue its laws, local officials cited the severity of venereal diseases in the past, while also stressing the law's moral good. Firmly opposed to the policy of repeal, Hong Kong's officials then frustrated the colonial office with their lack of action on the matter for over a year. This proved to be a problem, in fact, for them, because they effectively forfeited the chance to shape how repeal should be enacted. In a reversal then of its pioneering role in the making of CD laws across the empire, Hong Kong was later instructed via telegram, not dispatch, which would take weeks to ship and convey, to adopt the Straits Settlements law. Thus ordered, the governor ordered the repeal of Hong Kong's CD ordinances months later. And even so, compliance came with protests from its legislative council, as you can see here. Now, asserting their knowledge of local conditions and turning the language of free agency on its head, Hong Kong's dissenting lawmakers declared, quote, a very large majority of the women in Hong Kong do not regard medical examination as degrading or otherwise than incidental to their unfortunate calling, and they desire the attendance of medical officers to which to them is a safeguard, end quote. Similar to debates in the Straits Settlements, the freedom of native women and their identity lay at the very basis of these contentions. However, instead of saying that Chinese women could not be free agents due to traditional practices, due to, say, their traditional bonds to their keepers, Hong Kong's elites claimed that women involved in prostitution were, in fact, free and preferred a system of medical examination because of their vocation. In this perspective, the abolitionist concerns for constitutional violations wrought by medical surveillance were not applicable to Hong Kong, because native women, as well as others involved in prostitution, did not see the system of medical examination as an intrusion of their bodily freedoms. In this twist of logic, the rule of law idea became a malleable frame that allowed Hong Kong's elites to render native women as culturally different persons who chose their mode of legal subjection freely. So there could be no abuse of power and no cause of repeal in the socially different conditions of Hong Kong. Now, however clever, the claims were moot as repeal as a form of imperial policy was a fait accompli, was an established fact by them. And so Hong Kong acceded then to colonial office. So in the transformation of gendered sovereignty from the CD laws to the protection of women and girls ordinances, we can identify at least three ways that the rule of law idea was entangled in the production of racial difference as an object of law. Firstly, colonial officials could insist on the racially ingrained nature of prostitution and thus native women's lack of free agency, positioning the colonial state's illegal intervention through regulation as the only way to ensure that native women would be free from the fetters of what they call brothel slavery. There could be no basis for the rule of law unless the colonial state could place native practices under control and ensure women's liberty. Now, secondly, these administrators could alternately highlight that the abuses that occur when officials, particularly low-ranking native ones, were empowered to inspect and regulate brothels and their inmates, while native women were in principle free to seek medical examination and treatment. They were vulnerable to harassment or blackmail by corrupt informers and officials in practice. To them, remove regulation and its temptations of power, and British officials could then educate native women about their freedom to come and go as they wish in a territory under Crown rule. Treated as a universal principle, the rule of law was counterposed to the irregularities of colonial governance, which could be reformed. Now, finally, colonial elites could, on one hand, recognize that native women were free, but on the other, assert that unlike British women who possessed different notions of their rights and freedoms, native women desired colonial regulation. The rule of law ideal was in this dicey-like view an ethnocentric concept, not applicable to the colonies. Now, given these three racialized legalities, the rule of colonial difference was a product. I showed that the rule of colonial difference was a product of imperial control that emerged with the differing ways that colonial officials and elites engaged with the rule of law ideal as they grappled with the management of new subject populations and practices. And turning finally now to the contemporary ferment over rule of law indicators in our post-colonial present, I would contend that we will do well to inquire into who the ideal serves and how these persons evaluate social difference. Thank you very much. And special thanks again to Professor Roberts, the Transnational Legal History Group for the invitation, as well as to the support team at the Center of Comparative and Transnational Law. Thank you.
Well, thank you so much, Professor Lee, for that talk. Thanks, Aju, entirely to you. That was fascinating on many levels. I have a number of questions, so I'm going to get us started. But everyone, please, chat your questions into me. Let me know as well if you'd like, and I can unmute you and so you can join us more directly. So I think the first question I wanted to ask, so I was really struck by that point you made sort of about 2/3 of the way through the slides where one of the colonial officials was mentioning the slavery, the British gunships being used to stop slavery in particular, because I mean, coincidentally, I was mentioning that same sort of dynamic earlier in a separate conversation earlier today is sort of the classic, one classic locus of, a project that overall had this clear normative and very positive component, but that was actually used by the British to enforce, to enforce their power at the same time, to seize foreign ships, to take, often to take their contents, etc. afterwards. But so I was wondering about what your reflections are on sort of the temporality of that particular type of discourse and how in relationship to, I guess, the 19th century in particular. So we have the abolition of slavery in the early 1830s, and then by the, and it seems like by the time we're getting to the Contagious Diseases Laws and Ordinances, there's much more an emphasis on that sort of protection side, that sort of we're protecting you as the justificatory framework. Do you feel that was really on the rise in the period you're looking at, or how would you do you think that was sort of a long-term constant in the British Empire, sort of the tendency to justify everything in terms of finding one or another way to claim that it was for someone's protection?
Yeah, I think that's a great question. I certainly agree that there's a specific historical context against which the language of protection and the emphasis on protection, particularly by the Crown, gains particular meaning. I will say that maybe there are several things in my mind right now, so let me kind of parse them apart. If you look at the early modern empire, it's not that, say, the rhetoric of protection didn't resonate in the early modern empire, but the early modern empire, the one kind of centered in the Atlantic and powerfully kind of like, say, anchored within the, the North American and Caribbean colonies, what it kind of was an empire of settlement, in short. It was an empire where, say, settlers set forth, whether on, whether with charters or not, to claim lands. And so that, the initial kind of like, say, in this early modern part of empire, I mean, protection certainly was a, I think it was part of vocabulary of law and vocabulary of the vocabulary of sovereignty, of course. I mean, the age-old idea of the sovereign's duty to protect their subjects. But it wasn't, until I think, and Professor Roberts, I'll agree with you here, until the emancipation, until the abolition of slavery, until essentially the whole anti-slavery movement took hold, that protection, I think, gained particular salience. And in two ways, right? On the one hand, it gained salience amongst elites. When I pointed to James Stephen at the very beginning of the lecture or the talk, James Stephen was in fact a very powerful ally and very powerful member of the anti-slavery movement, and he was centered in the colonial office itself. So what's really interesting here is that, say, to these elites, after emancipation, the next big task for them was to ensure that the newly emancipated, newly free populations in the colonies would not be subject to the kinds of whims and the arbitrary power wielded by settler elites, white settlers in short, who mostly controlled the legislative assemblies. So amongst the British elite, the colonial in the empire, protection had a very particular salience after after emancipation. And this was largely fueled by the kinds of moral sentiments of the anti-slavery movement, which was very much religiously inflected, and also powerfully associated with, for example, the Quaker-based like Friends Society, Society of Friends, so on and so forth. Now, another kind of dimension in which, like, say, the language of protection took particular salience was that the empire looked different. After emancipation, the very social grounds of the empire changed. Because if one looked across, say, for example, the empire in the 18th century, one saw, colonies largely dominated and populated by white, basically English or British settlers. In this particular case, chattel slavery meant that, say, slaves were not human. And, say, the natives, the indigenous, were excluded from the very kind of, like, say, boundaries of the settlement itself. And they were kind of pushed out or exterminated. Now, if you look at the 19th century empire, that changed altogether. Emancipation essentially meant, for example, that you had now a large and potentially politically powerful group of free persons who over time could ascend to positions of power in the colonies, for example, but who were at that point faced with a fairly volatile white minority. And on the other hand, I think, say, this is also paralleled by developments in, say, Asia and and then later on in Africa itself, where then colonization no longer meant, for example, basically no longer meant genocide, no longer meant pushing out, for example, the natives. So one can say that the empire looked very different. The empire looked multiracial in the 19th century, and the language of protection took on a whole new significance. Now, of course, like say, we can. I've been talking mainly about the colonial empire, and I've left British India aside for the time being. But British India kind of experienced a very similar kind of shift, because it is only in, say, the end of the 18th century where the East India Company began to play the role of the divan, right, and start to arrogate to itself like sovereign powers. And later on, the 1857 rebellion, precipitated an entire kind of crisis in amongst, like, say, those who administered India with regards to their duties and obligations towards those that they governed, because it was seen that their insensitivity to religion, amongst at least the elites then, they saw that it was their insensitivity to religion that was the reason for the rebellion in the first place. And so then there was emphasis in British India that stemmed from British India, as Taruna Montana has showed, that say we have to protect the local practices of these say various kind of races that we are now administering in British India. So I would say that yes, the temporal context in the 19th century was quite different from the 18th century. And it basically placed the language of protection, I think, right in the center of things. Because, to put it very simply, the notion of protection was central to the very ideology of liberalism, the very kind of like premise of liberal empire being able to offer progress to subject populations. Yeah, I'll leave it at that. I can go more, but.
Yeah, sure. I mean, well, so I wanted to, so maybe following up on a particular angle related, in some ways related to that, and in some ways it can probably go in a number of different directions as well. I wonder about the, I'd love to hear more about the way that you understand the relationship between what was going on in the UK itself and the colonial legal developments as well. So let me just first, as a sort of factual clarification, so as I understand it, the first Contagious Diseases Law was the one in 1857 in Hong Kong, and
Yes.
then you have the ones in the UK, and then you have it all over the imperial world, which is, I mean, in and of itself, super interesting.
Yeah.
But, so I guess sort of to give a little more meat to what I'm thinking about in terms of the comparison between the colonial and the metropolitan context. So we did see that the same similar sorts of laws were passed in Britain. The difference was that there a powerful movement was able to form, an abolitionist movement that after not really that long, in comparison to some things, was able to get it to sort of push back against, I guess, a protection narrative being sort of analog being applied domestically, to say no, these laws are helping us, etc., and to get rid of. Whereas, so to what extent, I guess, does the difference lie in just growing political power on the part of that community in question, being able to say no, this isn't really protecting us, or was it, or what community, or what communities were sort of articulating those cases, versus to what extent were there two different kinds of law, or maybe, or how would you?
Yeah, the story is actually really complex, but very interesting to dive into. I had a student actually one time write a paper on the emergence of the Contagious Diseases Acts in Britain, and she remarked to me, this was for a paper for a class I taught, and she remarked to me what she found striking was that the main proponents of the laws in Britain when the CD Acts were passed were in fact medical professionals. And what she found very striking were their claims for the need for the law were in fact more centered around on moral grounds rather than medical ones. So when she kind of like plowed through the medical journals, what she found was like basically, it was a fuse of moral rhetoric. And so, but that being said, I think that points to one thing, and this is a finding of Philip Howell, that the main proponents of the CD Acts in Britain itself were, the medical profession, were lobbying and calling for, say, things to be done about this growing kind of epidemic of venereal diseases in the military. Now, what Howell observes is that a lot of these proponents, these medical officials, in fact, had served elsewhere. They served in Hong Kong, they served in Malta, they served in Gibraltar, they served in British India, jurisdictions where, say, variants of the CD laws were actually already in place. And so they played a fairly figurative role in, arguing for the CD laws in Britain itself. So when we so the story that she tells, and that I agree with, that the kind of turn to regulation really kind of was precipitated by, in fact, developments in the empire itself. With motivated, of course, centrally by the help of the imperial army, but nevertheless, this was a case of empire changing metropole, or rather, the colonies changing the metropole, not the other way around. Now, of course, like say, parallel to this, I think what happened there was also this growing abolitionist movement, and Josephine Butler kind of gained an ascendance and influence over time, especially as the Liberal Party kind of came to power in Britain itself. So the timing of the acts and the abolition of, like, say, these laws in 1886 was actually was partly due to the Liberal Party's rise to power and their control of government. And so in short, I'll put it this way: the abolitionist movement had very powerful allies, and so the reason why, say, Butler was able to, and her allies, her kind of like followers, were able to overturn the CD Acts in Britain had a lot to do with, say, their, you know, their relationships with basically ministers and so on and so forth, who they were able to persuade to abolish the laws. But what's interesting is that, like, say, as the kind of the even after the Tories reclaimed power, and say, if I would, this is not part of what I presented today, but I can kind of delve into it a little. But if you go to the 1890s, when, say, Joseph Chamberlain, a conservative, was, controlling the colonial office, the kind of the colonial elites and officials now had an opening to say, like, hey, now we have somebody who's favorable to our claims, and they try to fight again to reinstate, say, the regulation of prostitution in its like full, like, say, in terms of the full regime that was present in the 1880s and before. But even Joseph Chamberlain kind of like was reluctant to reintroduce, for example, compulsory medical examination, and partly aware that this would be politically controversial. I mean, in the colonies itself, I think what's really interesting about the abolitionist movement is that one of its allies, Joseph M. Butler's the person who helped edit Joseph M. Butler's memoirs was George William Johnson, the very clerk who was supervising the correspondence in the colonial office. And so what was really interesting is that I would read, for example, some of what the abolitionists were saying elsewhere, and then see the rhetoric directly replicated in his minutes when he received these laws from the colonies. And he would directly say, well, no, these are the arguments that we can bring against what these colonial elites are saying. And so the abolitionists had this like really expensive kind of reach. They also sent, for example, investigative teams across the empire to find out what actually happened, to counter, for example, claims by colonial officials and elites that the regulation of prostitution was necessary, for example. I think like the main people pushing for the reinstatement of regulation of prostitution in the colonies were in fact the mercantile elites and the colonial officials who were present there, who saw, for example, that a heavier hand was needed in governance, for instance. So this kind of interesting arrangement where you had a fairly international abolitionist movement with strong reach across various sectors of British government, and kind of a pushback coming from those officials who had experience in the colonies, as well as, like, say, mercantile elites who they often worked with. Yeah, so that's kind of like the array of like how of the politics of regulation, I guess.
Yeah, but fascinating. I find all of those. There's so many fantastic details in even the weeds of as you were mentioning the colonial officials, and then different ones that I wanted to follow up on that as well. So you had a mention of this in one of the comments by the colonial officials on one of your slides, but the potential that, as he was arguing, having these laws, what's it going to mean in practice? It's going to mean that then the police actually go to the brothel, and the brothel owner pays the money, and therefore it doesn't actually create a more protective system. It creates this corrupt network, which I think at almost every country, including the 20th century, including through today, you will find examples of exactly that sort of thing, innumerable ones, I think. But so I guess what I'm interested in is that how much do you think that sort of the potential for material corruption that sort of legal framework enables? How much was that a part of? I mean, it feels like that was sort of subordinate to these because there was a tension coming from higher levels, that was subordinate to these much bigger picture sorts of debates and positions. But how much of a role do you think kind of actual maybe
corruption? So if I kind of think through your question, I guess the question is like, how much corruption actually was there, right?
Yeah, I guess in the first place, how much corruption was there, and was that actually worthy? I mean, maybe another, maybe another way of or part of it is, to what extent did that, so the practical corruption, to what extent would that ever have been able to influence somebody sort of within the colonial government in one place or another, or were they somewhat removed and they had these bigger picture questions and issues that were determining their decision making? Maybe, I mean, the other, just so I'll get the last question. I was interested in to this as well, and then I want to ask someone else in the audience to pose their question.
Yeah, we also have some questions on the chat as well. Sorry.
Yeah, exactly. Are you getting questions in the chat as separate from the ones I'm getting?
Yeah, I think there's Cloud Cap Club.
Yes. Okay. So then, sorry, I didn't see that. So forget my questions, please.
No. I can respond to your questions, and then I have a question from Cloud Cap Club that I think maybe it'll be interesting to address. But maybe the question
from the audience members. So please take that.
No, I think the question of corruption is a really interesting one. It's very hard to get a clear sense. I would say that there is certainly a clear unease that you can detect amongst the colonial officials, both in the colonies and in Britain itself, regarding the activities of these, like, say, local officials, these police officers, low-level police officers that were sending around. There was in one case, I believe, like they highlighted the case of corruption involving I think two Malay police officers who were I think accused of taking bribes. I can't remember too specifically right now, but there was certainly, whether or not it was actually grounded in, like, say, a pervasive, actually existing pervasive landscape of corruption is hard to tell. Part of the thing is that, and the reason why it's hard to tell is that corruption did factor into the rhetoric against the laws. And so what happened is that, any kind of instance of corruption could be magnified. And so when Maxwell talked about, like, say, the propensity for blackmail, he was basically referring to that particular that anxiety. And that actually Maxwell's concern with the corruption of local officials was echoed by, say, the abolitionists who were petitioning people in Britain itself. And what, say, the abolitionists were saying is that, drawing from what we know of, say, the regulation of prostitution in the continent, in continental Europe, we know that corruption is rife. And so, since corruption is rife, why should we, allow for these subaltern, these low-ranking officials to kind of run rampant and bully vulnerable women into these, to them, repugnant forms of examination? So it was certainly a central theme, I think, in their kind of concerns with the rule of law. Yeah, I kind of want to. So I guess I'll just ask. There are two questions I got. Then we can see. One for Cap Club, which is the differences between the 1890s and nowadays. Whether geographic in terms of colonial distribution, and so I'm gonna
maybe if you, since
we're
a little bit short on time,
okay,
you read out both of the questions you got, and then I've got one as well, so I'll unmute the.
Okay, perfect. So okay, there's no question about the differences between 1890s and today, in the terms of the distribution of powers and the kind of and the kind of loss of local control, it sounds like.
Great. So I feel like this we could have a whole nother talk just on this final theme you're touching on now, this sort of the construction of that particular crown colony form of governance and its resonances. But as we're coming to the end of our time, it just remains me to thank you so much, Professor Lee, for such a fascinating talk with so many interesting angles and components on past and present governance.